Good evening, everyone. My name is Biro Edwin Roland, and I am a student here at our university at Université George Emile Parade. And today we are going to talk about alternative dispute resolution methods alongside with Mr. Professor Lee.
Hello everyone, I'm Michael Lee, the founder of Michael Lee Chambers. Thanks for having me.
Okay, so Mr. Lee, or I should call you Michael, right?
Yes.
What is an alternative dispute resolution? What are these methods, and why should they be more useful than litigation?
Okay, that's a pretty big question. We must first separate a domestic setting versus international setting. In the domestic setting, when I say domestic, it would be US domestic or Korea domestic, Singapore domestic. International means brings everybody in together, right? So in domestic setting, when you say ADR or alternative dispute resolution, it really means alternative dispute resolution. When you say alternative, it's always alternative to something else. So alternative to, in our cases, would be litigation, a default mechanism in domestic setting for resolving disputes. So traditionally, in every country, their default mechanism will be the litigation. This is where lawyers would go to the courtroom, present their cases to a judge, and wait to see if they get lucky to win their cases. And because sometimes in domestic setting it takes too long, or the judges may not be available to hear the cases right away, or judges may not have a particular background or expertise in particular areas, it's not suitable for some other industries. For example, in construction, when they have a problem, the parties, the owners or subcontractors want to resolve their dispute as soon as possible. Because if they don't, it creates more problems, because it's like laying a brick, right? If you don't lay first layers, then there is no second layer or the third layer. So it tends to delay everything. So they want the resolution fast. But in typical domestic litigation setting, you have to wait to be assigned the judge. And then hopefully you get assigned the judge soon. But even if you do get lucky and get your judges assigned, they may not be familiar with the construction method. So what happens is the lawyers would have to spend a lot of time and effort to educate the judge, just so he or she knows as much as they do. And then judges would have to know more. So it takes a long time to educate the judge, and it takes a long time to get the resolution that you seek, which then turns out that the whole process makes no sense, because by that time, the construction have failed, and then there are a lot of people, homeless people out there. So what they decided to do was, instead of going to a court, let's appoint somebody who's an expert in construction, who's not a judge, but who's always available, but someone we mutually respect. He or she is always available. We don't have to explain a whole lot because he or she knows more than us. So if we just simply present the problem, he or she will give us the answer right away. And that's sort of a beginning of arbitration. So arbitration is an alternative to a litigation. And arbitration still shares a lot of similar characteristics compared to the litigation, meaning the arbitrator is not interested in settlement negotiation. Arbitrator is not interested in listening to your whole heart, heartbroken stories. Arbitrator wants to know the facts and the laws, and then he makes the decision. And
this would have been exactly my next question. In what ways is arbitration similar to litigation when compared to other methods of alternative dispute resolution, like conciliation, negotiation, or even mediation?
We could perhaps get to that. So that's the one ADR method, alternative dispute resolution to litigation. Another one would be the mediation or conciliation. But what I wanted to address is that's domestic setting. It's truly an alternative to litigation. But when it comes to international dispute, the picture is quite different. For instance, company in China and company in US have a contract. When they have a problem, Chinese companies want to go to Chinese court.
Of course.
And the US company says, no, 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 let's go to US court. And the Chinese company says, no. So then where do you go? That problem isn't a recent problem. It existed about 100 years ago since we start trading with other countries. So the people, business people, and the lawyers all around the world realized that there may be a problem. So what they decided to do was about 70 years ago, they met in New York. They all made a promise to each other saying that if we create something that everybody can go to, and then make a decision, then it doesn't belong to US, it doesn't belong to China, it's a private arbitration. But in order to give it a real meaning, we will honor their award. Meaning, if the arbitrator has rendered a decision, we can take the decision to anywhere in the world, signatories, and then they will honor it, and we don't have to go for the second or third bite at the apple,
Yes.
meaning award is good. So that's called a New York Convention. And international arbitration, if it's truly an ADR, is an ADR2 litigation, but there is no sort of international litigation. So when it comes to international setting, international arbitration really is not an alternative dispute resolution. Right now, it is sort of settled that international arbitration perhaps may be the only way to resolve dispute. So in
Between
domestic
international
setting,
parties. Yes.
yes, for domestic setting, there are multiple ADR method, but when it comes to international, arbitration may be the only sort of a default mechanism for resolving disputes.
Okay. Thank you for your very long and great answer. I would like to step through to pre-arbitration requirements. As such, we have arbitration agreements which might include multiple or multi-tier clauses with mediation as a first step and, as you just stated, the final method being arbitration. How do these disputes typically are resolved? Do we have complications when the arbitration agreement is a boilerplate or just too simple? And how does this impact the arbitration and the dispute resolution?
Okay. Your question has at least three different sort of segments there. I'm going to try and capture them all slowly. So when I give you an answer, let's just assume that we're talking about international setting, not a domestic setting. In international setting, we do see multi-tiered clauses. They're typically laid out in a way that it encourages parties to try and settle their dispute on their own. And if they fail, they go to assisted settlement, meaning mediation. And then when that mediation fails, then they go to arbitration. Now, I used to see these quite a bit. The bad news is, though, the multi-tiered clauses in international settings are not doing great, meaning they're not being used, and then their popularities are not great as we want to see. And the root cause of this is that international arbitration, like I said earlier, is quite different from domestic litigation or domestic arbitration. The international setting, the lawyers who engage in the international arbitrations are the best of the best within their domestic settings. So these are the best people. And the arbitrators are one of the smartest people that you can find. So they know the implication of their decision. Their decision is so powerful that U.S. Supreme Court cannot even touch it. And the same goes to everywhere else. So they know the power that they hold in their hands. So what ends up happening is it's a very specialized area. And when these people receive a multi-tiered clauses, they view mediation as just an obstacle to get to the real stuff.
Yes.
So instead of treating it as an opportunity or genuine opportunity to try and settle, they just see it as an obstacle to get it over with, to move on to the arbitration.
Yes.
So when the lawyers see this, they say, okay, we just have to get it over with.
And what are
And
the
then,
implications of non-compliance with this step? Is it mandatory? Can it not be mandatory? Because as I understand it, we look at the contract, and I've seen contracts, and you can see that it says mediation first step and then arbitration finally. How are we supposed to? What are the practical
lawyers are
implications?
smart. The lawyers are smart. So you say if it's mandatory, yes, it is, if the contract calls for it. So what people do is they fake it. Okay, let's just try and settle, and then let's just fail it soon so we can move on. So that's why I said you can't bypass it on, if it says in the contract, but you give less meaning to it, which I discourage. But people tend to pay very little attention to that clause, but they still comply with it. But mediation, it's a different breed. Mediation requires a genuine heart to settle. Mediation requires not a legal sense, but a business sense as well. Business sense plus legal sense. And instead of lawyer-driven arbitration, it's a party-driven settlement negotiation. So when the lawyers get involved and who are dying to get to arbitration, mediation just happens to be an obstacle to arbitration. So they do it, they just don't give 100% of their effort.
But doesn't this not giving 100% and trying to go through to arbitration immediately isn't going against arbitration's principles, if I might say, like so to be efficient, just as you said, be efficient, cost effective, be fast, be quick, be exact. Why wouldn't these lawyers, but actually you have already explained why they wouldn't go to mediation first. What are some, I would like to talk about the differences between mediation, negotiation, and conciliation, because some of our viewers might might be confused about that.
Well, I don't know if I can help because mediation means different things to different people. Some call mediation a conciliation, and then the term can be used sort of interchangeably in different parts of the world. But the idea is there is a third neutral who, in essence, does not make any decision, but who facilitate settlement discussion. So meaning there is a mediator and then two parties who will come, and the mediator is a has a different sort of a nature or characteristics compared to arbitrators. Arbitrators, you can think that may be categorized as sort of a bully, because they get to make a decision and they are interested in making decisions. They are not interested in facilitating discussions because they know that the parties have failed before they came to him. But the mediator wants to listen, wants to address the real cause of their dissatisfaction, not just the legal sense. So mediator, it's a facilitator, whereas arbitrator is a decision maker. So the mediator, I think, gives more effort in listening to people. So it's quite different. What
Yeah.
was the question again?
I would have liked to see the differences between conciliation and mediation
Oh,
mostly
okay,
because
okay. Well,
negotiation it is quite clear because the parties negotiate without a third. Maybe if I'm correct, you should you are more experienced in this field than I am. So maybe if yes, you've answered my question pretty directly in any way. So
okay,
uh,
the variation that you may find is now who is this mediator, right? Sometimes they say switching heads. So the arbitrator or the judge may just switch heads and say, do you guys want to mediate? And then if parties say yes, judges will then say, okay, now I'm a mediator, so let's discuss. And then when that fails, then the mediator switches back, and then he becomes a judge and then rules on it. And in some cultures, that's normal. In some culture, that's unthinkable. And
yes.
in some cultures, the parties want the mediator to give some sort of a legal opinion as to the likelihood of their success if they were to go to arbitration or litigation, because they see him or her as a person with authority, and they respect the person with authority. So it doesn't have to be a ruling, but subtle encouragement of, I think you should take it. I think you should take $1 million.
I understand.
Then
Yes.
what they can do is they can report back to their clients or company that we didn't just settle out of my own opinion, but it was the mediator's suggestion. So that sort of justifies accepting the offer that the other side made, and it can be culturally important. So in some culture, you want the mediator to have some authority to suggest something, but the mediators who are trained with the common law style really hates doing it because they're trained not to meddle with the legal stuff. So they try to stay away. But in some culture, it's encouraged and it works better this way. And that's where you might see some form of conciliation sort of being mixed with
Could you
mediation.
give us a
But
few
it,
examples of states where this practice is more useful, more it works better? I
well,
personally would like to know.
well, in Asian cultures where the mediation actually is attended by the company representatives, it works better if the mediator uh, is capable of subtly suggesting or giving some sort of more guidance. Um,
Yeah.
and the hesitance comes from the other side or the mediator. If he or she is from the common law jurisdiction, then he or she hesitates saying it. But then parties needed. So you're in a weird situation where just say the number and we'll accept,
Hmm.
but the mediator refuses to say the number.
I would like to move to the maybe enforceability side, as we have talked about the New York Convention and the enforceability of arbitral awards. What about mediation, the talks between the parties? What happens if they agree in mediation and then disagree outside of mediation or after it concluded?
Well, that happens. But turns out, and then a few years ago, Singapore created uh, the Singapore Convention that sort of helps mediation settlement agreement and try to give it the same effect as the New York Convention. But setting that aside, traditionally, there is a theoretical discussion versus reality. So theoretically, it's possible you may settle during mediation, but then you fail to comply. And then the other side, which who didn't get paid, now has to restart the whole litigation or arbitration just so they get paid for what they have settled and agreed to already. Um, so theoretically, that's possible, but I think overwhelming majority of settlement agreement out of mediation is voluntarily complied. Um,
Yes.
it's voluntary. The high rate of voluntary compliance is a result of that genuine discussion. because they accepted the deal because they think they can comply with it. So usually it happens. But what if it doesn't? The lawyers have figured that out long time ago. So what in international arbitration, what we have is consent toward, meaning once you reach a mediation settlement, we can turn that settlement agreement into a enforceable arbitration award. So
Very
meaning that
interesting.
it becomes an award that is enforceable under New York Convention. So you have to comply with it because it has the same effect as an award. So the industry have sort of came up with a solution before Singapore Convention took place. But then a few years ago, Singapore Convention took place, and then now we have Singapore Mediation Convention, which means that if you are one of the signatory countries, if you have a mediation settlement agreement, it will be honored as if it was an award.
Yes.
So there are safety mechanisms to encourage settlement negotiations.
If we might try to turn back a bit to a pre-arbitration prerequisite, which mediation can be, if I understand, if the agreement is formulated and written and it's written very well, so that the parties will first submit to mediation. Can non-compliance with this mediation lead to the barring of parties to go to arbitration? If, let's say, the lawyers of one of the companies really does not want to go to mediation and simply just avoids this step altogether.
I think theoretically it could happen, but it would be a very bad lawyering because mediation by itself is voluntary process, and you have to give your heart to it. So instead of if a lawyer is smart and wants to skip mediation, he wouldn't just skip it because that would not be good. He would pretend to go along with it and just be unreasonable. And
Okay.
then mediation could just fail easily. So that way they would have a justification. They've met the precondition to arbitration.
Okay.
So you find that more often than a lawyer blatantly just skipping mediation.
I understand. So, Mr. Lee, if I'm correct and if I know my data correctly, you are from Singapore
I was born in Korea, raised in the United States,
and now
now
practice
live.
in Singapore? Yes. Okay. So, we've recently gotten a few articles from Reuters. We looked over them about the Singaporean, maybe you could correct me. I am not sure if I'm correct, but the Singaporean courts have tried to mix and move parties to arbitration during litigation, or some kind of they try to mix in litigation with arbitration or mediation. I am not sure I understand that it's a legal proposal or something like this. Maybe you could expand on this a little further.
Well, I'm not exactly sure what you're referring to, but Singapore is, first of all, I'm not Singaporean, so I'm not taking Singapore's
Yes.
side. I am US citizen, but I spent last, 16, 17 years in Singapore, and I helped building Maxwell Chambers. So I've seen Singapore in an earlier stage and then see how it sort of developed. Singapore does have a few of the unique concept that no one else has. So first one is, I'm sure you know SIAC. So
Yes.
that's the Singapore International Arbitration Center. And arbitration centers are everywhere. Every country has at least one. But what they have is they created SICC. It's the Singapore Commercial Court. It's a part of a actual Singapore court. And the parties, the difference between the traditional litigation is that in litigation, the territorial jurisdiction sort of dictates who can go to that court. So it applies automatically.
Mm-hmm.
But as I see, people can voluntarily submit their a claim to that court. In that sense, it's similar to arbitration. So it doesn't automatically get triggered unless you specify it. But the idea is Singapore International Commercial Court is there for the international commercial disputes people to voluntarily submit their dispute and not go to arbitration, but voluntarily go to Singapore International Commercial Court. And the way they set up the commercial court is quite unique. They pull judges from all around the world. So they're not just Singaporean judges, but they're, in essence, really good arbitrators. So they gave them a title of international SICC judges, and they're not a permanent employees, but they act sort of like arbitrator, but on the list of judges that they have.
Yes.
How successful they are, I'm not so sure. I think they've had some success, but it hasn't taken off like the arbitration does. So in Singapore, they have SICC, and then you have SIAC, and then they still have Singapore Mediation Center, so SMC, but then they added another one, SIMC. So they have SICC, SIAC, SIMC, because that's the Singapore International Mediation Center.
Yes.
And the relationship between SIMC and SIAC is quite unique. SIAC handles arbitration cases, but they know how valuable mediation is. So when arbitration is filed at SIAC, they encourage parties to try and mediate. And if they say yes, then the case gets transferred from SIAC to SIMC, to stopping the arbitration. And then if they fail to settle, then it comes back to SIAC. So that's quite unique. In other parts of the world, especially in the United States, for instance, in AAA or the ICDR, I was the head of Asia for the AAA ICDR for the last 15, 16 years. So I actually helped sort of frame this concept, because we knew that stopping arbitration to encourage mediation really doesn't work very well, because lawyers hate the fact that I don't want to, that you have to stop arbitration just so you can go to mediation and then come back and then you're,
Yes.
beginning.
It's lawyers.
So what AAA ICDR did was, instead of stopping arbitration, they have concurrent mediation or parallel mediation. So you have arbitration going on, but you don't stop arbitration. You appoint a different mediator, and then you go on a mediation on a parallel track. But arbitration takes typically very long time, but the mediation takes very little time. So the mediation can happen fast, and then the cost related to mediation is really, really not much. I think you pay like $400 to ICDR just to have another mediation set up. So since it's parallel, you're not wasting any time on arbitration, on mediation, because you didn't stop arbitration. But these are all the efforts to encourage mediation, but mediation, unfortunately, in international setting hasn't taken off like the arbitration did.
Thank you, Mr. Lee, Michael Lee, for being with us today. Unfortunately, our time is up, so I would say goodbye to our viewers. Thank you very much for listening to us today, and have a nice evening.